Hi, I'm Bethany Lukic. I'm one of the partners in our Los Angeles office of McGuireWoods, and I'm one of the co-chairs of our class action practice here at the firm and the litigation subgroup lead of our data privacy and security practice. I'm here today with one of my colleagues in the Los Angeles office, Justin Yetter. It's our pleasure to welcome you today from our own coffee shops to the third season of Frenemies. If you have listened in on seasons 1 or 2, you'll recognize this as the series where McGuireWoods intellectual property and data privacy and security teams work together to help marketing and legal departments understand each other, work together, issue spot, and maybe go from being frenemies to friends. If you haven't had a chance to watch one of our prior seasons, Cross into the Friend Zone, Trademark 101, or Companies Don't Share IP, the use and protection of content, know they're available for you on demand on our website. Today's episode is the one where California falls in love with privacy, the California Consumer Privacy Act in 10 minutes. This session is geared towards giving you a broad overview of the key provisions of the CCPA. In later episodes, we'll dig into the details and give guidance on some of the hot topics in the CCPA. All right, Justin, are you ready to get started?
Ready when you are, Bethany.
All right, let's go.
Privacy law in the U.S. is different from some other parts of the world, notably Europe. One reason the CCPA is a big deal is that it's the first comprehensive commercial privacy law to be passed in the United States. This means that it applies regardless of what industry a company is in or who its customers are. That is an actual quote from Alistair McTaggart, one of the original proponents of the CCPA, and also apparently a true story about how this law came into being.
Essentially, the entrepreneur proposed a ballot initiative. The initiative gained traction.
In June 2018, a compromise was struck and the legislature stepped in. Only 7 days later, it passed a bill.
The governor signed and the CCPA was born.
And then amended.
And then amended again.
And then regulations were published with still more rules.
And then the regulations were amended.
And then amended again. The CCPA is complicated, but don't worry. Here are the basics in 10 minutes. Let's start the timer.
So let's start with the basics. Who is covered by the CCPA and who has to comply with the CCPA? The CCPA applies to businesses and not just California businesses. A business is essentially any for-profit company that does business in California and meets one of 3 threshold requirements. It has annual gross revenues over 25 million. It buys, sells, receives, shares the personal information of 50,000 or more California consumers, households, or devices. Or it derives at least half of its annual revenues from selling consumers' personal information. It's this second prong that captures a lot of companies. For example, if you're a non-California business and you have a website that collects information from visitors who visit your website, you're likely to meet this second prong threshold. If you also then do business in California, then the CCPA is going to apply to you. You also need to pay attention to affiliates, parents, and subsidiaries. Even if you're an entity that doesn't meet this thresholds, if you are controlled by or control an entity that does meet these thresholds and you share common branding, then you have to comply with the CCPA as well. And finally, who is a consumer? A consumer is a person like you and me who is a California resident. For now, at least, the CCPA largely does not apply in the B2B context.
Consumers have 4 basic rights under the CCPA. Number 1, they have the right to notice at the point of collection about what information a business is going to collect and what the business is going to do with that information. Number 2, the right to ask a business to tell them the specific categories and pieces of their personal information that the business has collected within the last 12 months. Number 3, they have the right to tell the business to delete their personal information. And number 4, they have the right to tell the business not to sell their personal information.
So, what is personal information? The definition of personal information is far broader than things like name, social security number, driver's license number. It's defined as information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. It does not include publicly available information. But publicly available information doesn't just mean that you can Google it and find it on the internet. It means information that's lawfully made available by state, local, and federal governments. So the CCPA includes, but is not limited to, the following personal information. Things like name, alias, address, unique personal identifier, email address, account name, social security number, driver's license number, and then branching out, internet protocol address, online identifier, protected classification, biometric information, browsing and search histories, geolocation data, professional employment data, and inferences from all of these different kinds of data. It's a ton of personal information.
Whoa! Sales are another really important aspect of CCPA for marketers to understand, especially in the area of targeted advertising. The definition of a sale under CCPA is very, very broad. It covers what you think it means, so trading personal information for money. But it also covers situations in which the business gets virtually any other kind of value for releasing the information. We included the definition here so you can see just how broad it is. We'll also have a future episode in this series devoted solely to sales under the CCPA and strategies for dealing with sales.
So, can you share personal information? Yes, you can share personal information. But there are additional rules and regulations when you do share information. First of all, you need to disclose what you share, how you share it, the business purpose of sharing the information, and your privacy policy. If your privacy policy doesn't accurately disclose how you share information, then you need to update it. You can also sell data. And again, as Justin said, we have a whole episode dedicated to what constitutes a sale. But for today's purposes, note that sale is broadly defined, and you have to give consumers a right to opt out. You can also share data with service providers, but there are also special rules and items that you'll want to consider, including what is in your vendor agreements, and you'll likely want to update your vendor agreements to add things like potential indemnity clauses, requirements to use the data for only the specific use that you have contracted with that vendor for, and also requirements to make sure your vendors are using reasonable security measures. So, what happens if a business violates the CCPA? So currently there are two methods of enforcement. One is by the Attorney General. The Attorney General has the power to enforce all parts of the CCPA and issue civil fines. And you can see these fines, which range from $2,500 for each violation up to $7,500 if intentional, can really add up. We do know that letters went out from the Attorney General and enforcement has started. There also is enforcement by a private right of action for data breaches. And stay tuned for another episode on enforcement generally. There are statutory damages under the CCPA for data breach violations.
The concept of non-discrimination is built into the CCPA. What this means in broad terms is that you can't treat customers differently just because they've asserted their rights under the Act. The CCPA recognizes, on the other hand, that personal information has value, and that, for example, if someone tells you not to sell their personal information, it may cost the business the value of that sale. So, under the rules, it is possible to charge customers different prices based on the personal information they choose to provide or limitations they've set on how a business can use it. However, the price difference has to relate to the actual value of the information. This is a notoriously difficult thing to calculate, and there are a number of relatively complicated examples that are included in the regulations addressing it.
And so, what about all the other privacy rules? Does the CCPA replace those? So, it really doesn't. You still have to comply with all of the other rules in California, industry sector-specific laws, federal laws, and other states' laws. And it's a little bit of a maze. So, I think we've made our 10 minutes.
Let's talk about to-dos.
Okay.
For many companies, there's a lot to do. You need to know how your company processes personal information, put in place a privacy policy that's CCPA compliant, train employees, have a process for responding to requests to delete and do not sell and to know. Make sure your service providers are following the rules, and then you need to look back and update your policies at least once a year. And that is CCPA in 10 minutes.
Well, thank you for joining us for this whirlwind tour of the CCPA. The other episodes in Frenemies, Season 3, are now also available, and they include the one where sale doesn't mean what you think it is, what is a sale and why does it matter, the one with teeth, did the Attorney General really start enforcement on July 1, and what about private suits, and the one where we're still confused about California, what's in the proposed regulations anyway. And there's also an episode about Shine the Light versus the CCPA. So as mentioned in the beginning of this presentation, all of the other seasons are also available on our website for reviewing or re-reviewing. And please don't hesitate to reach out if you have any questions. We'd be happy to help guide you with CCPA.